Well, good afternoon, everybody. My name is Sandy Chen, and welcome to the Samfiru Tumarkin live employment law show on Facebook and YouTube. I'm a lawyer at our firm's Vancouver office, and I'll be around for the next half an hour or so answering any and all questions to do with employment law or even disability law. So please feel free to type in your questions in the box in front of you. Hopefully everybody can see and hear me. I can't see or hear anybody, so you'll have to put in your questions through the comment box. And I'll take the questions first come, first served basis. So if you're having issues at work with, there's a variety of issues you could be having at work. If you're having issues with a colleague, or hopefully not, but your boss, if you've been let go or if you've just been hired, anything to do with employment law, please feel free to put your questions in here. And I have some topics I wanted to talk about today. But if I'm talking about something and you have a question, please feel free to just cut me off and put your questions in. As I say every time I'm on here, I'm going to put priority to the questions. That's kind of the point of our live Q&A here. So let me see. We've got our first question here. So JX2, you're asking a disability law question. How much does it cost to get a self-directed disability trust set up? I can't help you with that, Jay, unfortunately. When I say disability law, I should clarify. I mean questions to do with scenarios where you have to go off work because of a medical issue. Okay, that's what I mean by disability law. Also, if you've applied for benefits through a disability insurance company and you're denied, that's disability law. So I should have clarified. So when I say disability law, it's kind of to do with issues at work or if you've applied but been denied benefits from your insurance company. So sorry, JX, so I can't help you with that one. Okay, we've got a question on Facebook. It's from Miranda. Your boss has started asking you to do work that you feel is unsafe, that you're and you're not properly trained for. How do I go about dealing with unsafe work? Miranda, that's a very good question, and it's one of the it's one of the issues that I deal with quite frequently. Unfortunately, every province has work safe legislation. Okay, and BC, if you're in BC, assuming it is the same. So the employer has a duty to provide a safe workplace. If you feel it's unsafe, then you have to raise that with your employer. And if you're not properly trained, you have to raise that with the company. Okay. And it's not either you or the employer that gets to decide whether a certain work is unsafe. It's work safe. Okay. So the first step is to raise it if you feel unsafe and say, I'm not doing this. All right. And if work safe determines that it's unsafe, then you don't have to do it. That's kind of the short of it. If it's something that's, well, I guess it depends on the scenario, right? Like the unsafe work is a very broad category. I don't know if you can provide more details around on what you're being asked to do. But any of that stuff goes through WorkSafe, and it's one of those things that they're gonna have to come investigate and determine whether it's safe or not. Okay, so Miranda, if you have any follow up or anybody else, if you have any follow up, please feel free to just type in a follow up question to the comments box. Okay, we got a question. Oh, this is the same question from Miranda on Facebook. Okay, we got a question here. Next question from JR. Is there a good resource or website to better understand the legal implications and stipulations of contract to hire positions? Jared, just clarify that question for me. When you say contract to hire positions, I'm assuming you're talking about an employment contract. I guess it depending on if you're the one drafting it for an employee or if you're the employee that's signing the contract, the implications are very different, right? In terms of a good resource or a website, obviously our firm website has quite a few blogs on employment contract. So if you go to employmentlawyer.ca, there should be a ton of resources there. Obviously these blogs and resources and websites, I know a lot of people do a fair bit of Googling these days on legal issues. What I'll say to that is, maybe it's a good start. And Jared, I just saw your follow-up comment. You're saying as an employee, um, you know, so our website would be a good resource to start, but I would say that there are just so many different factors in an employment contract, um, in your specific situation, um, that the resource, the blogs are a good start, but you should really get legal advice before you sign in a contract as an employee. And I'll give you an example of the implications. This is the most common one I see, especially for non-unionized or for non-unionized employees. Let's say you've been with a company for 10 years, right? And your employer all of a sudden presents you with an employment contract. Now, they might say to you, that employment contract, we just want to get some administrative paperwork done, or, we're just trying to clean up our, making sure everybody has a written contract. That contract may be a few pages long. In there, what I see commonly is a provision that essentially says, if we let you go, we can pay you the minimum severance required under the Employment Standards Act, right? And what that means is the Employment Standards Act says you get a week per year of service, basically, up to a maximum of 8 weeks. Typically, if you've been with a company for 10 years or more, you're going to get at least 9, 10, even more months of severance pay, at least, right? And that's what's called common law severance. And so the difference between you signing that contract and getting 8 weeks pay versus potentially 10 months of severance pay or more is huge. And so that's one of the most common implications, I guess, for an employee looking to sign an employment contract. Other stuff that's more straightforward, obviously your pay, everybody looks at the pay and the hours of work, right? Stuff people might not notice is that termination provision in that contract. There's other restrictive covenants the employer could be trying to impose, non-competitions, non-solicitations, confidentiality clauses. I've seen clauses where the employer puts a term in the contract saying, we can unilaterally change your pay, hours of work, and position at any time. Something along those lines, right? Maybe not as bad as that. So, I guess all this is to say is, every situation is very unique. But those are the major things to watch out for. I would certainly, if you're a long service employee, I would urge you to seek legal advice before signing anything. And that that goes equally for someone who's entering into an employment relationship for the first time. And if you're signing a contract, if you're leaving a job, a secure job, for a new job, and they get you to sign a contract that says we can give you 2 weeks notice to let you go, right? That's not going to put you in a very good position. So Jared, hopefully that answered your question. It's a very there's a lot of things to look out for. That was kind of a generic answer. Feel free to follow up if there's anything more specific that you were curious about. Okay, so we've got a question here from Maureen. You were suspended from work. So Maureen, I have the first part of your question. I can't see. I think your question was cut off. All I got was I was suspended from work in November 2021. So if you want to just retype your question, because it appears to have been cut off on my end here. Okay, so we've got the next question from Sanjay on Facebook. The question is, what is the legal limit on filing a claim after being let go from a position? Sandra, you're gonna have to clarify your question a little bit. So, what do you mean by legal limit? In terms of the monetary compensation you can ask for, I mean, it's, you can ask for $1 billion, right? In terms of the actual remedies, so what you're asking a court to award, right? So typically, a court doesn't have jurisdiction to award things like reinstatement, right? Or giving you a positive reference letter. So a judge cannot force the employer to give those things to you if you've been let go. Assuming you're non-unionized. Unionized employees, it's a bit of a different situation. So if that's what you mean by legal limits, Andre, I mean, there's money for sure is within the jurisdiction of a court to award, obviously. Other remedies you're looking for, it depends. It really depends on the situation. Certainly, if you've been discriminated against, you can, and the employer has, violated the human rights code. It is possible to get reinstatement. So, Sandra, if you clarify your question a little bit, maybe I'll be able to better answer it. Okay, next question we got from Julia. Julia asks, can an employer stop providing medical benefits as a cost cutting measure? Yeah, Julia, that's actually an issue I've had to deal with this week. I hate giving this answer, but it really depends on a few things. You start with your employment contract, right? If your employment contract says they can do it, then they can do it. If it's silent, it's more of an ambiguous question, right? The medical benefits typically, well, let me back up a bit. The employer can, do whatever they want to cut costs, right? The issue is, are you going to sue them over it, right? Can you sue them over it? If your contract says that they're going to give you benefits and they cut it, you can sue them for breach of contract, right? If they cut your pay by 20%, you can actually claim what's called a constructive dismissal, okay? And claim for severance pay. So between losing benefits and 20% of your pay, it's a matter of degree, right? And so I think the answer to your question is, if the benefits were, if you heavily relied on them, if your contract says they have to give it to you and they just unilaterally cut it, there's two options for you. Number one, you can either sue them for breach of contract, or number two, you could have a claim and say that's a significant and fundamental change to the terms of your employment, and claim for severance pay. So there's a lot of different factors in that question. It's, I can certainly see situations where, the employer, by cutting benefits, it wouldn't meet that threshold of a fundamental change, right? Because it's a small part of your compensation package. So yeah, Julius, I think the answer is, legally speaking, they can cut the benefits, but the issue is, are you prepared to kind of sue them over it, right? And the second issue is that enough to say that they've terminated your employment, basically? Most of the times, I would say it's probably not enough. So Julia, hopefully that made sense. If you have a follow-up or if anything I said didn't make sense, please feel free to type her in there. Next question we've got from Hussein. So boss changed your schedule after 15 years of the same shift, 6 a.m. to 2:30, and he changed it to 11 to 7:30 on the days, even when you asked him, even the days when you asked him, he said he has no one for the night. I want you to be the bridge between the day and night. Is he have a right to do that? So then I'm not sure if there's a case, and what I mean by case is a case, something that's similar happened to you, or something that's similar to happened in the past to another employee, that like a legal precedent. I can't think of anything that come to mind. I know that when you change someone from day shift to night shift, you can treat that as a constructive dismissal, right? This goes back to my answer to Julia earlier: is your boss can do that, right? But are you prepared to kind of say, well, this is a fundamental change, and because of that, I want severance pay. It involves leaving your job, right? A constructive dismissal. So in your case, I would say that because you've been doing the same thing for 15 years, and especially you have something in writing saying 6 a.m. to 2:30 p.m., that could be a constructive dismissal, which you can claim severance pay through. Because, and especially if it has a huge negative impact, like if you have, I don't know, let's say childcare responsibilities after 4 o'clock or something. If there's huge significant negative impacts to you because of the shift change, I would say that bolsters your case for constructive dismissal, right? So just back to my point about Julia, though, like your employer can do it, right? They can change your shift. The question you have to ask is, are you willing to leave your job over it and claim severance pay, right? If you've been there 15 years, it's probably, I mean, depending on what your contract says, but it could be, over a year's pay for severance. There's other factors to that, and you should definitely talk to a lawyer before you do anything about that. But one of the big factors I think in your case you're saying is, how does this shift change affect you, right? Are you even able to do it with other things? The example I gave you was maybe you have a child that you need to take care of. So hopefully that gives you some clarity, Hussein. But come if you're in BC or whatever province you're in. I mean, our firm has offices in Ontario and Alberta as well. If you're in BC, come talk to me about it afterwards. We can talk in a more private forum. We can see if it makes sense, right, to kind of claim for severance as opposed to accepting this change. And I'd want to see your employment contract as well, if you have one. Okay, next question. We got a follow up from Sanjay. How long can you wait to take an employer to court? Sanjay, that's okay. So I got you. That was what you meant by legal limit. I'm gonna tread carefully here. I'll give you general answers. Anything to do with employment law, there's so many different, I shouldn't say, but there's different tribunals, there's courts to go to, there's different causes of action, there's different things you can sue an employer for, right? And so with that, you can imagine that there's different deadlines for each potential claim you could sue an employer for. So the most common one is a wrongful dismissal, right? You've been let go. The employer hasn't paid you enough severance pay. You want to sue for wrongful dismissal. That's 2 years from the date of termination. Okay, but that's 2 years from the date you got notice, not the date, not your last day at work. Okay, human rights claims, barring special circumstances, are generally a year from the date of discrimination, right? If you've been let go because you're disabled, right, you have a year from the date of termination to bring a human rights claim. Employment standards issues, so stuff like unpaid wages, 6 months. There's even actually shorter deadlines for federally regulated employees. I'm not going to go through all of them, Sandra, but hopefully that gives you a sense. Some as much as 2 years, some as little as I think 90 days. So, if you have a more specific claim or a forum, feel free to put that in your follow up. Okay, we've got another question here from JX2. If you're offered another position from either the company that owns the company you work for or another company within the group, What can you do to ensure it is treated as a continuance rather than a fresh start with zero severance or benefit entitlements? Also, how can you ensure that you get the opportunity to get back your original position if and when it is brought back? Okay, so let's deal with the first part of your question there. I mean, typically, so I guess my question to you is, I assume you've been let go, JX2, or maybe you're working at your notice period. Um, to ensure that it's treated as continuance, you have to put it in writing. Okay, your employment contract with whether the company, the parent company, or a subsidiary, or whatever it is, it has to say that we recognize past years of service with previous company, right? For all purposes, including severance. That's how you ensure that it happens. Um, I'll, in some situations, you actually don't need that. I don't want to get into it because I don't know too much about your scenario, JX2, but in some situations, you actually don't need it in writing. It just the recognition of past service is there by operation of law, which means that it's just implied in very specific situations. I'm not sure if it'll apply to you, but I the best way, the easiest way to do it is just put it in your contract. Um, to the second part of your question, how can you ensure that you get the opportunity to get your? I mean, so Jake, that's a tougher one. You'd have to get the company to agree to it in writing, right? If you're non-unionized, you're not really, if you've been temporarily laid off, you're not really entitled to be recalled to your original position, right? The temporary layoff is generally treated as a termination of your employment, which you should get set. In most cases, if you've been temporarily laid off, you should be entitled to severance pay if you're non-unionized. But if you're non-unionized, there's no way to ensure you get the opportunity back unless you agree so, preferably in writing with the company. Okay, so JR, your follow-up comments, better understanding. You just wanted to know what's the best way to draft a contract, especially if my situation deals with offer letters, RTR. I am currently engaged in unilaterally correspondence with recruiters. I want to make the process easier where you initiate communication by posing my own terms of employment with a contract. Yeah, Jared, I mean, in most cases, the employer is going to give you the contract. And obviously it's going to be weighed in their favor. The key when you get that draft contract, JR, is to get it reviewed by a lawyer and propose terms for your own, or cross out certain terms that the employer has proposed. Okay, so we got a follow-up from Julia. You have a dependent with diabetes, so you have a lot of household medical costs that you will be out of pocket for. Yeah, Julia, I think if it's significant enough, and I'm just going back to your original, right? You had the question about the medical benefits. If it's significant enough, Julia, and it's in your contract that they'll give you benefits, I certainly think there's a case there if you want for constructive dismissal, right? But Julia, just keep in mind that involves quitting your job and claiming for severance, and that's not obviously a light decision. That it's something you should talk to a lawyer. Come talk to me about it if you're in BC, about whether it makes sense for you financially to do before you actually do it. But I imagine those are pretty significant costs that you'll have to be out of pocket for. The other option, Julia, obviously, as I mentioned, is you don't necessarily have to quit your job. Is you can sue the company for breach of contract, right? Whether it's in writing or verbal, you can say it's implied term of your contract that they will give you benefits, and now that they've cut them, I mean that's a breach of contract, right? That the cost that you have to incur for, you can claim against that, claim for that against the company. Whether that's the best way to go about it, I guess it depends on your situation and your relationship with the company, and it might be a bit uncomfortable suing your employer while you're still working for them. Okay, so I had a few more questions here. Question from Facebook, on Facebook from Rena. Can your employer refuse to provide unpaid sick days? I mean, the short answer is no. You're entitled to a certain amount of sick days by right under the Employment Standards Act, some of which are paid, some of which are unpaid. If you need a longer leave of absence, if you give them a doctor's note, they have to accommodate your whatever it is, your sickness. If you got the flu, flu is actually, if you have something preventing you from working for an extended period of time and you get a doctor's note, the employer has a duty to accommodate that by giving you that time off in almost all cases. Okay, so JX2, you got to follow up. You're not in a union. You're working under two positions with a company. Both have been eliminated. You may be interested in other positions within the group of companies or at another location in Canada or at another time. Yeah, Jay, it's X2. It sounds like you've been let go. They should be giving you severance. If there's other positions within that group of companies, I assume this sounds like a pretty, a big national company. You'd have to apply, right? And if you get the job as part of the negotiations, you'll have to say, if I accept your employment offer, I want a term to be that you recognize my past years of service. That's the only way to kind of ensure that your service is recognized. Otherwise, I don't think it will be. Okay, I don't think your situation where it'll be the past service will be recognized by operation of law. So you're going to have to put that in your employment contract. Absolutely. Okay, we got a question here from Jason on Facebook. Your employer has decided to move to a new location. If I cannot travel that far from my position, would that be considered a resignation? So just, I mean, it depends on how far. Let me just kind of back up because this seems to be a common theme in the questions today. We've had a question from you about your employer moving. I think we had a question from Julia about the benefits. And then we had a question from Hussein about the shift changes. So you've got to, the employer has a lot of power, right? So they can make these changes as their business needs, or they can make it for, a stupid reason, whatever reason they want. If they make a change like that, you have to decide whether you're prepared to lose your job over it. What I mean by lose your job over it is, so for example, Jason, if you don't want to go that far, right, you can claim constructive dismissal and say, you've moved, this is a change or a fundamental change in terms of my employment. And so I'm treating that as a forced resignation or a constructive dismissal, right? So that's the first step is, are you willing to lose your job over this change and sue the company for it? Because you're losing that steady income, right? Jason, in your case, I can tell you there's been quite a few cases in the past, so precedents, where the company has done that. They've moved, 200 kilometers, 300 kilometers away. And a judge has said that that's a constructive dismissal. That is a fundamental change to the terms of your employment. And so that's not something you're legally obligated to accept. And you can claim for severance if your employer does that. So I think, it is a resignation if you say that you're not going to go work out that new location, Jason. But it's almost a forced resignation, right? The employer is the one that caused the resignation. And so legally speaking, that's called a constructive dismissal. Anything in the questions that have been asked today, anything that constitutes the legal term is, fundamental unilateral changes, right? So not every change is a fundamental change. Jason, your situation, if they moved really far, it is a fundamental change. So it's just a matter of degree of how far they change and how that would affect your commute to work. The other caveat I should put on that, and this will be the last question that I take, but the other caveat I put on that is, if you have a written employment contract, look at your contract, right? Some of the contracts say the company can make these changes. And so if it says that, that might be, well, obviously not good for you. but that might answer any questions about whether the company's allowed to do that or not. I would say in all these situations where the company's making these changes that impact you, have a significant impact on you, talk to a lawyer about what you can do about it, because it really depends on so many specific facts of your situation. I'm giving very general answers because I don't want anybody to act on my advice. But before you go and do something like quit your job over it, talk to a lawyer about it and see if they can do anything about at least getting some severance pay out of it. Okay, guys. So I think well, we got a last one from JX2. I'll do. How much to review a contract if and when necessary? Yeah, so it depends on how the lawyer. I'll tell you my rate is $350 an hour. Other lawyers might be higher or lower. So yeah, if and when, please feel free to reach out to me. My contact should be on the screen, or if just go to employmentlawyer.ca and my contact will be on there. Sorry guys, that's all the time I have for today. Hopefully I was able to be of some help to you guys. My colleague Dan's, if I missed anything or if anybody has any follow-ups, my colleague Dan's on tomorrow, 1:15 p.m. So, but I'll be back in 2 weeks. So yeah, thanks guys. And I hope everybody has a good weekend.